North Dakota has a straightforward and landlord-friendly lease termination framework that reflects the state's practical, no-nonsense approach to regulation. The governing law is found in North Dakota Century Code, Chapter 47-16, which covers landlord and tenant relations, along with Chapter 47-32, which addresses the eviction process. Let's start with no-cause termination. For month-to-month tenancies, North Dakota requires either party to provide at least 1 month's written notice before the end of the rental period. The notice must be given at least 30 days before the next periodic rental date. So, if rent is due on the 1st of the month and you want the tenancy to end on the last day of March, you need to deliver notice before March 1st. The notice must be in writing and should clearly state the date the tenancy will end. For year-to-year tenancies, North Dakota requires at least 3 months' notice before the end of the annual term. This longer notice period for annual leases is important to remember because it's substantially longer than the 1-month requirement for monthly tenancies. If you miss the 3-month window, the lease may automatically renew for another year. For fixed-term leases of less than 1 year, the lease expires at the end of the agreed term without additional notice required, unless the lease specifies otherwise. If the tenant remains in possession after the term expires and the landlord accepts rent, the tenancy converts to a periodic arrangement, month to month if rent was paid monthly, or year to year if it was an annual lease, under the same terms. For week-to-week tenancies, 1 week's notice is required from either party. Now let's cover termination for cause. For non-payment of rent, North Dakota is one of the fastest states in the country. The landlord can file for eviction once rent is overdue, and the process can move very quickly. North Dakota uses a notice and demand for rent framework. The landlord provides written notice demanding payment, and if the tenant doesn't pay, the landlord can proceed with filing an eviction action. The specific timeline is tight. Under North Dakota's eviction procedure, once the landlord files a complaint, the court can schedule a hearing within as few as 3 days in some jurisdictions. This rapid timeline gives landlords the ability to address non-payment situations quickly and efficiently. For lease violations other than non-payment, North Dakota requires the landlord to provide reasonable notice of the violation before pursuing eviction. The statute doesn't prescribe a specific number of days for most violations the way some states do. Instead, courts evaluate whether the landlord gave the tenant a reasonable opportunity to address the issue based on the nature and severity of the violation. For violations that can be corrected, providing written notice identifying the problem and allowing a reasonable cure period, typically 10 to 14 days for most situations, is considered best practice, even if the statute doesn't mandate a specific timeline. Courts generally look favorably on landlords who can demonstrate they gave the tenant a fair chance to fix the issue before pursuing eviction. For serious violations, including criminal activity, drug-related offenses, and conduct that poses an immediate threat to health or safety, North Dakota allows the landlord to pursue eviction without providing an extended cure period. The landlord can file an eviction action based on the violation, and the court can schedule a hearing on a shortened timeline. North Dakota also has specific provisions addressing situations where the tenant substantially damages the property. If the tenant intentionally or negligently causes damage that significantly impairs the value or habitability of the premises, the landlord can terminate the lease and pursue eviction along with a claim for damages. One thing North Dakota landlords should understand is the state's eviction process, which is handled through district court. The landlord files a complaint, and the court issues a summons requiring the tenant to appear. The hearing is typically scheduled within a relatively short time frame, often within 1 to 2 weeks of filing. If the court rules in the landlord's favor, a judgment for possession is entered, and a writ of restitution is issued. The sheriff then carries out the physical eviction. North Dakota's eviction process is generally considered efficient. Straightforward cases can move from filing to physical removal in approximately 2 to 4 weeks. The state doesn't have the heavy court backlogs that slow down evictions in more populous states, which is a practical advantage for North Dakota landlords. On the tenant side, North Dakota provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we discussed in our North Dakota habitability video, the tenant can provide notice and allow the landlord a reasonable time to make repairs. If the landlord doesn't act, the tenant can pursue remedies including lease termination. Active duty military members are protected by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. This is particularly relevant in North Dakota given the presence of military installations including Minot Air Force Base and Grand Forks Air Force Base. North Dakota enacted protections for victims of domestic violence under Section 47-16-17.1 of the Century Code. A tenant who is a victim of domestic violence, sexual assault, or stalking can terminate the lease early by providing written notice along with documentation such as a valid protection order, a police report, or a statement from a qualified professional. The tenant must provide a minimum of 30 days' notice. The landlord cannot charge early termination fees, and the tenant's liability is limited to rent through the termination date. North Dakota also addresses the issue of abandonment. If a tenant vacates the property without notice, removes most of their belongings, and stops paying rent, the landlord can treat the lease as terminated due to abandonment. The landlord should document the situation carefully, photograph the unit, keep records of any attempted communications, and note the condition of the property. North Dakota law then requires the landlord to handle any remaining personal property according to statutory procedures, including providing notice before disposing of abandoned belongings. North Dakota strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove doors or windows, or take any physical action to force a tenant out. All evictions must go through the court system. Landlords who engage in self-help face civil liability for the tenant's damages and can have their eviction cases undermined by their own improper conduct. One practical consideration unique to North Dakota: the state's harsh winters can create situations where a tenant needs to leave quickly due to a heating emergency, or where a landlord needs to access the property urgently to prevent freeze damage. While these situations don't change the legal framework for termination, they do create practical urgencies that both parties need to navigate carefully. A heating system failure in January may prompt a tenant to claim constructive eviction, and a landlord who needs to make emergency repairs may need to coordinate access with an uncooperative tenant. Having clear emergency access provisions in your lease can help manage these situations. North Dakota's oil boom, particularly in the western part of the state around the Bakken Formation, created unique rental market dynamics that affected lease termination practices. During peak oil activity, rental demand in cities like Williston and Watford City skyrocketed, and the transient nature of the oil industry workforce led to high tenant turnover. While the market has stabilized somewhat, landlords in western North Dakota should be aware that the employment-driven nature of their rental market can affect vacancy rates and the frequency of lease terminations. North Dakota requires landlords to return the security deposit within 30 days of the tenant vacating the property. The landlord must provide an itemized list of deductions if any portion of the deposit is withheld. If the landlord fails to return the deposit or provide the itemization within 30 days, they may be liable for the full amount of the deposit. North Dakota does not provide for double or treble damages for failure to return the deposit, which is more forgiving to landlords than many states. For the complete guide to North Dakota lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.